Hi, my name is Indra and my topic is on alternative dispute resolution. So what is alternative dispute resolution, or ADR? ADR is a process that is offered by the court to help resolve disputes between parties without having to go to trial. So by using ADR, you may not have to file a lawsuit, and even if you do file a lawsuit, you may actually be able to avoid a trial. So what is the benefit of using ADR? It's usually less formal, less expensive, and less time consuming than a trial, and it may give the parties more control over when and how their dispute is resolved. An ADR process can be initiated by the parties at any time after all the parties have appeared in the case. All they would need to do is file a stipulation to use alternative dispute resolution form, which I will show later on. The most common types of ADR for civil cases are mediation, arbitration, and settlement conferences. Mediation is a confidential, non-binding process in which a trained mediator facilitates communication between disputants and assists parties in reaching a mutually acceptable resolution of all or part of their dispute. The mediator is not the decision maker and does not resolve the dispute, the parties do. However, a mediator is often able to more fully explore the parties' underlying interests, needs, and priorities. Mediation is a more flexible process, which is less formal and may reduce the time and costs that are often associated with a trial. Arbitration is a binding or non-binding process where an arbitrator applies the law to the facts of the case and issues an award. The goal of judicial arbitration is to provide parties with resolution that is earlier, faster, less formal, and less expensive than a trial. The arbitrator's reward may either become the judgment in the case, if all parties accept it, or if a trial de novo, a new trial, is requested within the required time. If the arbitration was non-binding, either party may reject the award and request a trial de novo before the assigned judge. If a trial de novo is requested, the trial will usually be scheduled within a year of the filing date of the complaint. Parties may stipulate to binding or non-binding arbitration, or if the amount in controversy is less than $50,000, it is subject to mandatory arbitration. Settlement conferences are used to assist the parties in negotiating a resolution of all or part of their dispute. A settlement conference may either be voluntary or ordered by the court. It may be conducted by the judge assigned to the case, another assigned judge, a volunteer attorney, or a private judge who evaluates the strengths and weaknesses of the case without issuing any decisions or orders. So here we see a stipulation to arbitrate and stay proceedings for the Sampson versus Emerald Catering case. The format is on a pleading paper with the appropriate margins, and as always, we'll want to remember to adhere to the local guidelines when writing a stipulation to arbitrate. We'll also see the caption box with all the information on Ina Suffren, the attorney for our defendant, which is Benjamin and Sarah Sampson, and then the information of the plaintiff, Emerald Catering Company, along with the case number and the date for when this was filed. You'll also see the beginnings of the body of the agreement between both the parties to arbitrate. So this part of the body outlines the agreement between both of the parties to arbitrate, with the signatures of both lawyers for the defendant and plaintiff at the bottom. Here we have the stay, which outlines what needs to occur during arbitration for the proceedings to stop. It's the formal document ordered by the judge for the two parties to meet for arbitration so that they can resolve their dispute and hopefully not have to go to trial. And it's signed by the judge as well at the bottom. Here we have an ADR form that can also be used as a form of alternative dispute resolution. Typically, this is used when there is no requirement for a stay. And the reason we might want to use this form is if it's too early in the litigation process and there are no pending deadlines. In this form, I constructed it and I did it as if both parties wanted to do a voluntary settlement conference. So that has been checked off. And it also has the signatures of both the plaintiff and the defendant. And the bottom is signed by the judge. And after this has been signed and filed, this means that both parties can meet together and hopefully resolve their dispute without having to go to trial. Thank you so much for watching my video. Hopefully now you have a better understanding of alternative dispute resolution.